Welcome everyone. I acknowledge that I live and work on the Aboriginal land of the Turrbal Jagera people of Meanjin. I pay my respects to elders past and present and to the emerging leaders who continue the work of caring for country and fighting for rights and recognition. Today, we will be hearing from Robin Banks. Robin is an expert in disability discrimination law and education standards and was the Anti-Discrimination Commissioner of Tasmania for 7 years. Please welcome Robin Banks.
Thanks, Alicia. And I'm going to share a screen, and I just want somebody to confirm very quickly that the interpreters are still visible on the view. So I'm going to go to share. So can people, because I can't see you anymore, is that working?
I can see the interpreter, one of the two interpreters right now.
Fantastic. Excellent. All right, so I too recognise the unceded land, in my case, of Lutruwita, within which I live, work, study, create and gather with friends and family. I pay my respects to the traditional and continuing custodians of Lutruwita, the Palawapakana people, promising to listen and learn and walk beside in the struggle for rights. So, lunch with a lawyer. I've had my lunch. I hope you all have something there to keep hunger at bay. So I'm going to be talking about your rights as students or people with disability in relation to education. I will talk about some of the broader rights that we have under discrimination law, just because it's silly not to cover them as I go through, but this is very much focused on education rights. So I'm going to give an overview of relevant laws and policies. I'm going to talk about what discrimination is unlawful, because not all of it is, how it's experienced and what that looks like in terms of discrimination law, and also what options you have for dealing with discrimination that you experience. So hopefully there'll be plenty to chew on at the end of it. So there are a number of laws that protect us in terms of our equality rights, our rights not to be discriminated against. We have, first and foremost, at the international level, what are called human rights treaties, and they contain within them a universal right to equality and a universal right to non-discrimination. So we all have those rights, and those have been recognised across the world. And Australia has signed on to all of the human rights treaties that exist internationally, but most importantly for this presentation, we have signed as a country the Convention on the Rights of Persons with Disability, and we have said that we will be bound as a country by that convention. So we will fulfil the rights set out in it for people with disabilities in Australia. The Disability Convention, the Convention on the Rights of Persons with Disability, or the Disability Convention, has a number of parts and it has some core principles, but most importantly, I guess it's important to know that it has a section, a very detailed section covering education and training. So that covers all levels of education and training. It also has parts, for example, that cover accessibility and the built environment. So that's accessibility both in terms of the physical environment we work in, but also information accessibility and other forms of accessibility, communications, etc. It covers our rights in relation to sport and recreation, housing, health, work, other forms of accommodation, the right to life and access to justice, and to be recognised as capable of making decisions in our own interests. So there's lots of stuff in the convention. It's a pretty amazing document, and Australia, there's a committee at the United Nations that looks after the convention and deals with countries that are not complying with it. And at the moment, the chair of that committee is an Australian woman with disability, Rosemary Kayes, who is at the University of New South Wales. So we're right up there, I guess, in terms of that commitment under the Disability Convention. We also have a number of domestic laws, what would be called domestic laws, so laws in Australia that prohibit discrimination. First and foremost, or most importantly for Queenslanders, the Anti-Discrimination Act, which has been around since 1991. We also have federal laws, laws that apply across Australia. So the Racial Discrimination Act was passed in 1975, the Sex Discrimination Act in 1984, the Disability Discrimination Act, perhaps most importantly, 1992, Age in 2004, and the Fair Work Act, which deals with our industrial rights, was passed in 2009 and includes protections against discrimination in work contexts. Every state and territory in Australia has an equivalent of the Queensland Anti-Discrimination Act. Some are newer, some are older, some are more comprehensive and some are less, but we all have these protections. And many other countries have similar laws. So if you're an international student, you might find it interesting to find out what your home country has in terms of discrimination law in relation to disability. So the model that the Act has, or all of our discrimination laws in Australia have, is that they rely on individuals who are affected by discrimination making a complaint. So they're very much focused on dealing with those individual complaints and looking for ways to resolve them. They pay limited attention to the prevention of discrimination and to ensuring that organisations and individuals comply with the law. But I'll come back to this because the Disability Discrimination Act, which is a federal law, does actually do more than most state and territory laws do in terms of prevention and compliance. They also set out some broader educative and research activities or capacities for the organisations that administer the laws. So, who or what do the laws apply to? So every one of us in Australia is protected under discrimination laws, and every person and organisation in Australia is required to comply with those laws. So we're required not to discriminate against others in our day-to-day lives, in the way we interact with people. So that's really important. These aren't special laws for specific groups of people. These are laws for everyone and that apply to everyone equally. So everyone has rights. We have the right to be protected from discrimination, harassment or bullying, all of which are unacceptable at any level and are unlawful forms of discrimination. We have a right in broad terms, and I guess these are just a couple of examples of what it means under discrimination law. We have the right to be assessed on our own merit, not because of something about us that puts us into a particular category of people. And we have the right to learn, to work and to live in a safe and positive environment, an inclusive environment that values us for who we are, whether that's our home life, our workplace, our education environment or the broader community. So really important to understand that it's about each of us being treated as the human being we are and not judged because of something about us that people can see. As I said, the law applies to all of us and we all have to comply with it. That means that we have an obligation personally and organisationally, if we're part of an organisation, not to judge others, not to decide that somebody is good, bad or indifferent because of something about them, whether it's their race, their gender, their disability, but to take them on their personal merits. We have an obligation to discourage people from engaging in discrimination or harassment when we see that happening. And as an advocate, the next one is very important to me, and that is my obligation to encourage others to stand up for their rights, but also for me to stand with them in achieving equality and justice. And we have an obligation to treat each other with respect. And that word respect comes to us through the international human rights conventions. At the core of those conventions is the idea of the inherent dignity that we all have as human beings and the right to be respected for that dignity. So complaints, it's an individual complaints model. And it's important to understand that if you've been discriminated against, you can make a complaint yourself, or somebody could make the complaint on your behalf if for some reason you can't make it. For example, parents can make a complaint on behalf of children. And in some circumstances, a disability organisation can make complaints on behalf of its members who are affected by discrimination. And so that's important to know. It's not just about the individual affected who has the right to complain. And those complaints can be made against any person or organisation who is thought to be responsible for the discrimination. Now, you don't have to be an expert to make a complaint. If you can identify who it was who did the thing to you that you think was discriminatory, you put their name or their organisation into the complaint form, and you don't have to get it technically correct. The organisations that manage the complaints will check that that detail is correct so that the complaint can proceed properly. And you can also make complaints against anybody who aids or permits or asks somebody else to discriminate or encourages another person to discriminate. And there's a quite famous case based in Coffs Harbour where a man with a physical disability made a complaint about a cinema that was being refurbished, renovated. And in the renovation process, they weren't going to make the cinema accessible. And they got permission to do that from local council. And so he complained not only about the cinema for its failure to make the cinema accessible to him as a person who used a wheelchair, but he also complained that the council was permitting that to happen. And he was successful in that complaint. And that's a really important complaint because it says, local government and government have responsibilities to prevent discrimination when they can. So it's important to understand how broad the law is in that sense. So I think I said earlier that not all discrimination is unlawful. So what is unlawful discrimination? When is it that discrimination is against the law? So for discrimination to be unlawful, first of all, it has to meet the definition of discrimination, and I'll come to that. It has to be discrimination on the basis of what is called an attribute, and I'll come back to that. And it has to be in connection with an area of activity. And again, I'll talk about what that means. So that's the core. For it to be unlawful, it has to meet those three elements of the test in discrimination law. And it's pretty much universal, that way of thinking about what is unlawful discrimination. So, key concept or a key requirement is that there's discrimination. And discrimination in broad terms means treating a person differently and badly, less favourably, or doing something that has a less favourable effect or a disadvantaging effect on a person. So that could be, I'll come to that in a second. So when we talk about less favourable treatment, so I treat you differently and badly because you've got a disability, that's direct discrimination. So the refusal by a school to accept the enrolment of a student with disability at their school is direct discrimination because the person is being treated differently and less favourably than other prospective students going to that school who want to go to that school. So that's direct discrimination. And the easy way to remember this is it's directed at the person because of their characteristic, whether it's their disability or something else. Secondly, we have the idea of indirect discrimination. So where, for example, everybody is being treated the same way, so there's no different treatment, it's the same treatment being afforded to everyone, but it disadvantages you because you have a disability, for example, then that is what we call indirect discrimination. So a good example of that is when organisations have very rigid work hours. So you have to come to work, you have to be at work at 9 o'clock and clock on, and you have to work until 4:30, and that's when you get to go home. Those rules apply to everyone. But because of particular characteristics some people have, that's more difficult for them to comply with. So it disadvantages them. So for example, a parent with small children who have to be picked up from school or from childcare at 3:30 in the afternoon is disadvantaged by that rule because they can't comply with it without interfering with their caring responsibilities. So that's an example of indirect discrimination because same rule applies to everyone, but some people are disadvantaged by it. So let's go through direct discrimination in a little bit more detail. Less favourable treatment on the basis of a person's protected attribute. So something about you that is covered by discrimination law. It need not be the only reason for the way you've been treated, the fact that you have a disability or you're a woman or you're from a racial minority. It can be one of a number of reasons, but if it is part of the reason, then that's enough for a discrimination complaint to flow from it. This kind of discrimination often arises from overt or unconscious bias or prejudice. So, for example, often people with disability talk about being treated in a particular way because people have low expectations of them. Now, that's a prejudice, a view that, you can't have high expectations of people with disability, but and it's unfair. It is definitely less favourable. So, for example, not giving people the opportunity to participate in a particular training program that might lead to their promotion because you think they won't be able to fulfil it or they won't be interested without actually asking them or giving them the opportunity would be a form of direct discrimination. And the person who's doing the discriminating, whether it's a person or an organisation, doesn't need to intend it to be discriminatory. It doesn't have to be a deliberate, and really targeted thing that they do. It can be done out of thinking you're acting in somebody's best interests. That is still, if it has that effect of being less favourable, then it's still discrimination. We don't have to prove the person intended the harm to happen. For indirect discrimination, so the way people talk about it mostly is that there's a term, a rule or a condition, a requirement or a practice that's in place that applies to everyone, but that disadvantages people with a particular attribute more than other people. So that example of work hours is a rule in place that applies to everyone. We all have to get to work at 9 o'clock and finish at 4:30, but people with particular attributes are disadvantaged. And I used the example of people with small children, so who have caring responsibilities. It might also be that because of disability, you have to wait on a support worker to come to your house in the morning to get you ready to get to work. And if the support worker, you may not be able to book them in at the time that would enable you to get to work at 9 o'clock, or they might be late sometimes, and that would disadvantage you, make it harder for you to meet that requirement. Or you might be on forms of medication that mean that the morning, it's hard for you to get going in the morning, but you can still work that spread of hours, but later in the day, starting later in the day. All of those would be requirements, ways in which that inflexible work hours requirement could be indirect discrimination. And then the second part of this form of discrimination is it has to be unreasonable in the circumstances. So there might be reasons that an organisation has to have inflexible work hours. Increasingly, I think most organisations would struggle with that, proving it was reasonable. So it's an important element, but not one that we're going to get too caught up on at the moment. Again, the person or organisation that sets the rule or imposes the condition doesn't need to be aware that it has the effect of disadvantaging particular groups of people. The best case scenario is that they don't understand that, it gets drawn to their attention and they immediately change their rule or condition to make it more flexible, to remove the disadvantage. And sometimes that happens, I'm glad to say, but not as often as we'd like. And this sort of discrimination, I guess, most commonly arises because people keep doing things the way they've always done them. Oh, but we've always, required people to come to work at 9 o'clock. What's the problem with that? is a sort of classic. And, you know, I've often heard people say, but that's how we do it. And so for me, it's a question, I often ask the question, but why do you do it like that? Why, you know, why is this such an important element of the way you're doing business or treating people? And that can be a really important conversation to help people to see that they could do things differently and in a way that didn't discriminate. As I said, the second part of what makes discrimination unlawful is when it has a connection to a specific personal characteristic. And we call those characteristics in discrimination law attributes. So we all have a range of attributes. Some people would might use the term identities. It's the same idea. It's that you know, you're a woman or a man or a person who's trans or gender questioning. You're a person with disability. You're from a racial minority background, whatever that attribute, and all of us have multiple attributes, but for discrimination to be against the law, it's got to be in connection to particular attributes that are listed in discrimination law. And generally the characteristics that are listed have been identified as being an ongoing cause of social disadvantage. So it's not every characteristic we have as a human being, but the ones where people have experienced prejudice and discrimination in the past and continue to do so. And it's generally not something that we have chosen to have about ourselves. It's not, you know, the fact that I've got my hair done in a particular way or I wear particular clothing. So it's that idea of choice is sort of interesting and worth thinking about. So in terms of that idea of attributes, governments over time have identified that some groups have been historically and continue to experience disadvantage. So that includes racial minority groups, women, people with disability, gays and lesbians, and many more. And we keep learning about how particular groups are being disadvantaged, and that attribute might get added to discrimination law over time. In Queensland, the Queensland Parliament has specified that there are 16 attributes that are the basis of protection. So if you have one of these attributes and you experience discrimination because of it or related to it, then the Queensland Act protects you against that discrimination and you can make a complaint. So under the Queensland law, importantly, the attribute of impairment is listed. So Queensland uses the language of impairment rather than disability. It means much the same thing across all of the country. But so impairment is in there. If you are discriminated against on the basis of an impairment or a disability, you could make a complaint under the Queensland Act. There are, as I said, 16 in total. So these are some of the additional ones: sex, relationship status, pregnancy, etc., etc. Political belief or activity, gender identity, sexuality, intersex status, family responsibilities, and importantly, if you are an associate of a person with one of those other listed attributes and you're discriminated against because of that association, they might be your partner, a family member, or a friend, then you can also use the Act to challenge that discrimination you're experiencing. So the word impairment, and in other parts of Australia, disability is the term used, includes a very diverse range of conditions or characteristics. And this is a summary of the kind of scope that it has rather than a list of what is in the Act. So any physical limitations or disfigurement that a person has, any sensory impairments they have, like any hearing or sight loss, neurological conditions like multiple sclerosis, motor neurone disease, or neurodiversity, psychological and psychiatric illnesses are covered, learning disabilities and intellectual impairments and things like acquired brain injuries are covered, injury and illness. So if, for example, you have long COVID, just to be topical, you would be protected against discrimination on the basis of that condition. And also injury. So you might have a temporary injury, and if you're discriminated against because of it, you might have broken your leg, for example, you're discriminated against because of that injury, or you experience a disadvantage because of that injury, then you're covered. It also covers both past, present, future and presumed impairment. So if somebody thinks you've got a disability because of something else about you and discriminates against you, then you're protected. If somebody presumes that because of something about you or your family history, that in future you might end up with a disability, for example, they'll refuse you insurance because you have a family history of heart disease, then that would be covered as well. And if you, for example, had a disability in the past and you were discriminated against because of that, you would be covered. And there's some classic cases involving insurance companies where they have refused insurance, for example, life insurance or travel insurance to people who have had childhood cancer, for example, or who've had one incident of mental illness in the past. So all of those impairments are covered by the Act. And that kind of conduct by the insurance company, for example, is a form of unlawful discrimination. So as I've shown with that previous slide, the definitions of impairment or disability are very broad. It's sort of hard to find people who don't have an impairment or a disability in our world. But it's important to understand that how serious the impairment is, or severe, what type it is, or how you came to have it is irrelevant in discrimination law. It doesn't judge you because you happen to be driving too fast in your car and you ended up with a physical disability as a result of an accident. You're still protected. What is important, what is relevant, is whether or not you experience discrimination linked to that. So that's the core, at the core of this, is that your impairment only becomes relevant if you're discriminated against because of it, in the case of discrimination law, and everything else is sort of set aside. Finally, you have to show that what happened to you, the discrimination, happened in an area of activity, life activity, that is covered by the law. And again, I've highlighted that education and training is an area of activity that is covered. And I'll come back to that. But here are the rest of them. Employment, whether it's paid or voluntary. The provision of goods and services. So when you go to buy something from a shop, or you go to buy a house, or you go to all those things, that's the provision of goods and services. If you want to hire a hall or some other sort of venue for an event, that's covered. Superannuation and insurance is covered, so you can't be discriminated against in the terms of superannuation or insurance. If you are buying or selling property, or there's a gift of land, that can't be just done in a discriminatory way. Housing and other forms of accommodation are covered. Membership of clubs and the activities and management of clubs are all covered, as is how the state government and federally, the federal government, administer their laws and programs. So if they have a program that's for homeless people, but they rolled it out in a way that excluded homeless people with a particular disability, for example, that would potentially be covered by the law. Local government activities are covered, as is access to premises and places. So buildings, parks, all those sorts of things are covered by discrimination law. So that's probably a lot to take in. It feels like a lot from my end, but I'm going to just give you some examples and ask you to unmute yourselves and engage with these examples and give me your thoughts as we go through. So the first example I have is John. John has autism and he's doing art history at uni, and his art history class is going on a trip to the museum. His lecturer has suggested that John not join the trip, as the lecturer feels that John might find it difficult because of noise and other aspects of the visit to the museum. So the headline question is it discrimination? Is it covered? So let's unpack that a bit. What attribute does John have? Does anybody want to throw up an answer to that?
Autism.
Yeah, is that an attribute that was listed, autism? Or is it part of an element of one of the attributes?
An element.
Okay, so what is the attribute? Thinking about that list of 16 that were
okay. Impairment.
Yeah. So the attribute is impairment. Absolutely. Autism is one of the many impairments or disabilities that are covered. Secondly, what's the area of activity? So we had that list of work and clubs and premises. Probably the most important one in that list. Anyone?
Education.
Education.
Yeah.
Thank you. Excellent. Absolutely. So it looks like impairment discrimination. Question is it discrimination in the area of education? So is it discrimination? Is it direct discrimination or indirect discrimination or not discrimination at all? What do you think? You're not getting marked on this, so you can go for broke.
Indirect.
Why do you say it's indirect?
Because they're not deliberately excluding him.
Really? Do you think they said to everybody?
Oh, no, direct, because the lecturer actually singled him out.
Singled him out, and that's a good way. You know, that's why doing these exercises is interesting, because you start to realise, oh, actually, this is something that was directed to him. The teacher didn't talk to everybody else about it being a difficult trip, just John. So it's direct discrimination. It's on the basis of John's impairment, and it's in education. And it clearly would disadvantage him because he wouldn't get the benefit of the conversation and the teaching that goes on at that trip to the museum. Okay. Second one. This is a story from the Sydney Morning Herald. The headline is "Taxi Driver Fined for Refusing to Carry Guide Dog." And this was from 10 years ago, but it still happens. So I just pulled one up from some time ago. So a taxi driver wouldn't allow a person who had a guide dog with them to ride in their cab. So first of all, what's the attribute?
Disability. Blindness.
It's disability, so it's impairment. That's right. Oh, so disability in general terms, but impairment under Queensland law. Absolutely, it's disability. What's the area of activity?
Accessibility, travel, transportation.
So travel, that's a good way of thinking about it. It's travel. So travel is the provision of taxis is a form of travel, and it's a service. So it's discrimination in the provision of services. Okay. Under federal law, there's separately, they talk about public transport or travel. So, you know, it's covered everywhere in Australia. It's just might be under slightly different bits of the Act in different places. But public transport and the refusal or problems with public transport because of disability are covered under the idea of provision of services. And finally, is it direct or indirect?
Direct.
Yep. Do you want to explain why you say that?
It's pertaining to the one individual, and it's directly done by the driver, right? So the driver isn't directly engaging in direct discrimination. Had it been the organization and there was a policy, something like that, which disprivileged people with visual impairments, then it would be indirect, right?
I think if it was still targeted at people with vision impairments, it'd still be direct. But if the taxi driver said, "I don't carry dogs or animals in my cab," it might be indirect because that disadvantages people who need guide dogs, who rely on guide dogs for wayfinding. So it could be, and I've certainly had the experience of a taxi driver trying to argue that they just didn't allow any animals in their cabs. But all taxi services in Australia have to permit the carriage of guide dogs, even if they have rules about other animals, other dogs. They always have to carry guide dogs. So it is direct discrimination against a person on the basis of disability or impairment in the provision of services. Well done. Okay, next one. So Nalini is, again, a university student and she's blind. She enjoys going to clubs and pubs with her friends. Some clubs tell her she needs proof of identity in the form of a driver's license to get in. Oh. So what's the attribute?
Impairment.
Impairment, thank you, because she's blind. What's the area of activity?
This one's a little tricky because I'm going with it's not discrimination, but maybe I'm wrong.
Okay, all right. If it were discrimination, what would be the area of activity?
Provision of services.
Provision of services, access to places, so access to premises and provision of services, absolutely. So is it discrimination or not? So I can't see the person who was saying that. So why are you thinking it might not be?
I mean, I would argue that everybody's required to show an ID to enter because of age, right? You're over 18 to be served. So she looks young. It's nothing pertaining to her disability, but more of an, delivery of services, right?
Yep.
But she was 17, and so they do need to verify.
Yep. Okay. So
something like that. Maybe I'm wrong.
You're right to say that, they might have a right to require proof of age. That's not what they're asking for. They're asking for a specific proof of identity in the form of a driver's license. Now, how likely is it that Nalini, as a blind student, has a driver's license?
Very low. She probably have a state ID, but not a...
She might have a state ID. So if they accepted a state ID that had age on it, then it wouldn't be discriminatory. But because they require her to have proof of ID in the form of a driver's license, and they require that of everyone, so it's a rule that applies to everyone, which makes it indirect, she's disadvantaged. She can't do that. She can't get a driver's license. And so she is disadvantaged because of her impairment. Yeah, so it is indirect discrimination because there are other ways, and this is where I said earlier, so a lot of the time these things arise because it's been how it's always been done. So, driver's licenses are a really convenient way for a person to prove their age. And they have a photo on them, so prove that you're the person with that identity card. But they are a discriminatory form of identity document. So the club could, or the clubs could choose to say, well, no, we're going to get rid of that requirement. People could use a driver's license if they've got one, but equally they could use some other form of photo ID that has their age on it. Yeah. So next one. We believe everyone should have access to a great movie. So what we've got here is a bunch of people at the cinema watching the screen, listening to the dialogue that's going on. Who is disadvantaged by that in a cinema? Who doesn't get the full benefit when they go to a cinema unless there are modifications?
Deaf or blind?
Yep. So people who are deaf and people or deaf or hearing impaired, people who are blind or vision impaired won't necessarily get the same benefit from this experience. Again, what's the area of activity?
Access to places?
It's, I mean, I guess the question is, can they get in? Yes, they can get in. Okay. So it's not the place that's the problem. It's the way the service is provided. So again, it's access to services. Yeah.
Oh, yeah.
Yep. And is it direct or indirect? Is there people being targeted because of their disability, being told they can't come in because of their disability?
No, it's indirect.
It's indirect, isn't it? The rule or condition, it's not stated, but in order to fully enjoy the cinema experience, you need to be able to hear and see. So that's the rule. And, you know, unfortunately, increasingly we see modifications being made in cinemas. So we have captioning and sometimes, I'm glad to say, audio description of what the action on the screen, but it is a form of unlawful discrimination to continue to deliver services of this sort without any modifications. So we've got here a person in a wheelchair, set of steps. What's the attribute? That's easy. This is like really easy.
Impairment.
Mm-hmm. Thank you. You're all letting one person do all the work. What's the area of activity? Come on, somebody.
Access?
Yep, access to premises. It could also be something else, depending what happens in that building. So if she works in that building, it could be discrimination or it could be employment. If she's studying in that building, it could be education. But it is definitely access to premises, yeah? And then finally, is it direct or indirect discrimination? Again, what's the question you ask for direct? Is it targeted at her?
No.
No, even though they're pretty obvious, aren't they? They're sort of blatant, but they're not put, those steps are not put there to stop a person with disability. They're not targeted at her or other people who use mobility devices. So it's indirect, yeah? And whenever I do this kind of thing, people go, but it's so direct, it's so obvious. It's like, direct doesn't mean obvious, it means targeted. So as long as it's just there for everybody to deal with, it's an indirect. And effectively what those steps say is, if you want to come into this building, you have to climb steps. Yeah? And people with mobility devices or mobility impairments who use things like wheelchairs can't meet that requirement. So they're disadvantaged by it. Yeah?
Is it still indirect if it's like sort of put there specifically to keep people with wheelchairs out?
Oh, that would be very direct. Are you thinking of an example?
Well, I'm mostly thinking of like anti-homeless architecture, but I do know that sometimes people make like architecture and stuff deliberately difficult to navigate for certain kinds of people to like stop them from congregating in that area.
Yeah.
But like everyone has to deal with it.
Yes.
So I guess, I don't know. Although
No, I think that
doesn't
would
really
be
change the
direct,
outcome.
and it might be direct on the basis of homelessness, which isn't a protected attribute, unfortunately, but it's definitely direct. And if it's, that's a really interesting question. It may still be indirect if it's not put there because of disability, it's put there because of homelessness. But yeah, I think, I mean, it's an interesting example. Thank you. It's always good to get one that stumps me. I'll think more about that. But yeah, it would be rare. I hope it would be rare for access to premises to be done directly. There's a case going on at the moment where a man who used a wheelchair here in Hobart complained about a new development as part of the Parliament precinct in Hobart. And he complained because one of the three major entrances to the area is a set of stairs, and it's the easiest one to access. Of the three entry points, it's the easiest to get to for a person using a wheelchair. But then you get to it and you can't get up the steps. He complained before the building was built about it and said, please don't, could you put a lift in? They didn't. In the legal complaint that was filed in the court, the complainant alleged both indirect discrimination because it was steps into a building, But he also alleged direct because he put them on notice and they persisted with their decision to put those steps in and not give an alternative means of access. So sometimes if people are deliberately excluded by not fixing a problem, then it could become direct. Yeah. All right. So is there any other conduct that is against the law? And the answer to that is yes, because all of these other things are forms of discrimination, but they've been separately identified in law. So sexual harassment is against the law because it's less favourable treatment based on your sex or gender, and it's less favourable because it's unwelcome sexual conduct, basically. Disability harassment is unlawful under the Federal Act, the Disability Discrimination Act, or DDA. Discriminatory advertising. So putting an ad that says people with disability need not apply, that would be really blatant and really discriminatory. But having sort of requirements in ads that have a discriminatory effect. Accommodation that said no pets or animals allowed would be discriminatory advertising because a person, again, who uses a guide dog couldn't lease that property. If you request somebody else do something that would be unlawful or you encourage them to, that is unlawful. If you ask questions about a person's disability or other characteristics that are irrelevant, so asking whether a person has a disability that might impact their ability to do a job, for example, is likely to be unlawful. And there's a lot of unpacking for that, and I'm not going to go into it, but there are things about asking information about people's characteristics that are unlawful. Racial and religious vilification is unlawful. So that is the idea of saying really hateful things publicly about people of racial or religious minority groups with a view to making them feel unwelcome or to incite other people to treat them badly or dislike them as well. So those are forms of race or religionism. I don't know what that word is, racism or religionism that are specifically named in discrimination law, as is victimisation. Now, victimisation is, it's important to understand that it means if you make a complaint of discrimination, you mustn't be treated badly or threatened because you've made a complaint. And many people don't complain because they fear the consequences of complaining. And victimisation is expressly unlawful under discrimination law. So important to understand that there are protections for people who complain and people who are witnesses in complaints. All of that is really the sort of scope of the protections. It's important to understand that there are exceptions or exemptions in all of the laws. So, for example, if doing something differently would cost far too much, and I say far too much, not just more, then there might be a defence or an exception available to the organisation. There are a whole range of them. I'm not going to go into lots of detail because I think they come up after a complaint has been made sometimes, and they shouldn't be the reason you don't complain about discriminatory conduct. So if you make a complaint, what happens and what can you achieve through making a complaint? So not much point complaining if you don't think it's going to achieve anything, and certainly that is a fear that many people have. So let me just move to the next slide. So many organisations, including the University of Queensland, have internal complaint mechanisms, and you can use those. Hopefully you can get support to use those, and I suspect we'll talk a bit more about that during the question and answer session. But yeah, they're internal processes, and sometimes they're a really good way to resolve complaints. But you don't have to go through an internal complaint process to go to the external bodies that deal with discrimination law. And in Queensland, it's the Queensland Human Rights Commission, which is responsible both for the Human Rights Act in Queensland and also for the Anti-Discrimination Act. Federally, for all of the national laws, it's the Australian Human Rights Commission. And every state and territory has a body like these that is responsible for dealing with complaints under their laws. The external complaints. If you make a complaint, you make it to the Commission. There are no costs involved in doing this. So you don't have to pay a fee to complain, and it's a free process. All of the elements of it are free. The usual thing that happens after a complaint is made is the Commission will try and bring the parties together to have a conciliation, which is a meeting to try and resolve the complaint without having to go to court or into a more formal process. If the conciliation is successful, so the complaint is resolved, the agreement reached between the person who made the complaint and who the people or organisation they were complaining about, that agreement is documented and they're asked to sign it and they're bound by it. So they have to do what they said they would do to resolve the complaint. If it isn't resolved while it's being dealt with by the relevant commission, then at the federal level, the person who made the complaint can file their complaint, lodge their complaint in the federal court. In Queensland, if it doesn't get resolved, that process is in the Queensland Civil and Administrative Tribunal, QCAT. Again, there is no cost to file in the Queensland Tribunal, QCAT. There is a small filing fee, a small fee involved in filing a complaint in the federal court. I think it's about $55, but it may have gone up slightly. Again, the tribunal or court will try and resolve the complaint, assist the parties to resolve the complaint through a mediation process. So bringing the parties together, trying to persuade them that they would be better off not going to court. If that doesn't happen, then there's a hearing, and you'll all have seen plenty of courtroom dramas, and that's the kind of stuff that goes on. Perhaps not as aggressive as what you see in American courtroom dramas, but it's a process where evidence is presented by the parties, people are cross-examined, and at the end of the day, the tribunal or court goes away, reviews all of the evidence they've been presented with and makes a decision. And that decision is binding. Whatever is ordered, the people who are subject of those orders have to do what is ordered. So in the conciliation or mediation process, almost anything is possible to agree to, any outcome. The only thing that I guess the important thing to say is you can't agree to do something that's illegal or unlawful. But you often, very often see apologies, both private and public apologies, acknowledgements of what has happened and how it's affected somebody, orders, agreement to pay compensation, so financial amounts to make, to remedy the harm that's been caused. Some people ask, rather than them being compensated, they ask for a donation to be given to a particular charity, and that happens. Organisations quite commonly agree to ensuring that they conduct education and training with their staff about discrimination obligations and rights. An organisation might agree to review and amend their policies and procedures that have been shown to have a discriminatory effect. They might change their service delivery because the way they were doing it had a discriminatory effect. Or they might make modifications to a physical setup. They might put a ramp in or a lift or any of those other things. All of those things and more are possible through a conciliation process. If it goes to court, it's much more common to get compensation orders. That's the most common outcome of a court finding that discrimination has happened. They occasionally will order an apology, and they might order that the organisation or individual not do it again. That seems pretty obvious, but sometimes we get those orders. And do other things that will overcome the loss, injury or humiliation experienced by the person. They can order re-employment of a person who might have had their employment terminated because of discrimination. And they might order changes to buildings or services, although that is pretty rare. So the really common one of that list is compensation. Very quickly, there are some other things, and I said I'd come back to this. There are a couple of things that are possible under the DDA, the federal law, that really are about trying to get things right without needing to make a complaint. And they include organisations developing disability action plans, or the Commission issuing guidelines on how things should be done in relation to, for example, designing bus stops. I know there's a guideline on bus stops. And there can be industry-wide standards where an industry says, well, we're going to adopt this voluntary standard that will remove discrimination. As well as that, the Federal Parliament recognised the need for more active approaches, and they did that under the DDA in the form of saying that disability standards could be made. I'll come back to standards, but first of all, action plans. Action plans are a mechanism to identify areas of possible discrimination in an organisational structure and to develop a plan to address those barriers, to remove them, to ensure full inclusion. The idea is that it allows organisations to take a planned approach over time with budget allocations that they can think about in advance. And organisations can register their action plan with the Australian Human Rights Commission. The University of Queensland has an action plan, a disability action plan, although it's now expired, and I'll come to that. And it says that UQ is committed to building an accessible and welcoming environment for all students and visitors. And from our campus facilities to academic resources, we provide a number of services that focus on creating an inclusive environment where all students have the same opportunity to succeed. So a big statement about how important that UQ thinks getting it right is. So the Disability Action Plan, the most recent one, expired in 2021. I understand there's work on a new one, but it still isn't publicly available. And the reports under the previous one, 2018 to 2021, the plan actually says those reports, those annual reports, will be available on the Action Plan website. I could find the 2019 annual report, but I couldn't find more recent ones. The 2020 report was behind a login wall. So it is really important with action plans that reports against the plan are publicly available so that people can hold organisations to account for their action plan, what they committed to doing. So turning to disability standards very briefly, we have under the DDA provisions that say that standards can be made, and what standards do is detail what must be done as a minimum to fulfil the responsibility not to discriminate on the basis of disability. We have a standard for education that was enacted in 2005, and I'll refer to that as the education standard. We also have standards for accessible public transport and a standard for access to buildings. So you should see over time improvements in those three areas to accessibility. The education standards cover all education providers, including tertiary institutions such as universities and TAFEs, but also preschools, kindergartens, public and private schools, and every other form of education and training that you can think of would be covered. And they're about ensuring equal educational opportunities for all students with disability. They cover in different sections education-related activities. So there's a whole part of the standards that talk about curriculum design and ensuring curriculum is designed accessibly. Admissions processes, teaching methods, extracurricular activities. So it's not just about what happens in classrooms, it's what happens in the education community. Assessment, so exams and other forms of assessments, and the physical environment, which is partly dealt with through a reference to the access to premises standards. Under the education standards, all education providers are obliged to consult with students with disability or prospective students, and if they're under 18, with their parent or guardian about what their needs are for a fully inclusive education. They are required to consider and implement reasonable adjustments to provide the student with equal opportunity, unless it would cause an unjustifiable hardship. And I guess we see that at UQ in the form of student access plan. So that's the reasonable adjustments that the university is agreeing to implement for each student. and they are obliged to prevent harassment and victimisation of students with disability. Reasonable adjustments, really important idea. So they're individual. They're designed to respond to the particular needs of an individual, because even if students have similar disabilities, each of them is unique and they may have specific learning needs as a result of, or educational needs as a result of the way their disability affects them. Reasonable adjustments should be flexible because student needs and contexts change over time. So what you need when you start at university might change because you're doing different sorts of courses, or your disability has changed, or you've had treatment for some aspect of it, so your new needs have reduced. So no point having a student access plan that never gets reviewed and amended over time. And they have to be agreed. So they have to balance the interests and the needs and the rights of the student with disability with what the university can do in light of, for example, what accreditation requirements there might be for particular courses. In determining whether an adjustment is reasonable, there's a whole lot of things that come into play. So what's the impact of the disability on the students' learning, on their participation and their levels of independence? What's the student's view about their preferred adjustments, what worked for them in the past? So that's a really important consideration. No point implementing something that's been tried before that didn't work. What impact might the adjustment have on relevant parties, such as other students, staff members and the provider, the education provider at the university? What are the costs and benefits of making the adjustment? And an important consideration, but one that's sometimes overstated, is the need to maintain or to understand the essential requirements of a course or program, and to ensure that the adjustments don't undermine those requirements. So universities need to be ready and responsive. To be ready, they need to do everything they can to remove the known barriers to equal education opportunities, and to ensure staff understanding of education rights and of student access plans and who they can go to if they don't understand what they need to be doing. So that's the ready. They also need to be responsive, and they do that hopefully by working proactively with individual students to develop their student access plan and to ensure it is fully implemented. So very quickly, I'm just going to go to finally why people complain and why they don't. So people complain because discrimination affects them. Often people don't complain until it affects them economically, but that's not a requirement. You can complain if you've been discriminated against. And it might be that they've had enough. They've put up with discrimination for a long time, and now it's beyond putting up with. They might have expected better of the situation, particularly if an organisation talks the talk, says we're a really great organisation, we're really inclusive, and then a person experiences discrimination, then there's probably a higher likelihood a person might complain then because they expected better. If it's something they're particularly keen to be involved in, then they're more likely to complain if they're excluded. Or if something that the discriminatory thing that happened was particularly embarrassing or humiliating to them. Why don't people complain? And I'm sure some of you have responded to the survey that was conducted at UQ this year, and some of these responses reflect the responses to that survey. People feel they can't afford to complain because of the cost, in terms of money, in terms of their emotional wherewithal, and also in terms of the time that it would take, they think it would take. People don't complain because they've had a bad experience in the past when they've complained, and so they don't want a repeat of that in their life. It might be that their life is already too complex and they just don't have the emotional and other wherewithal to go through a complaint process. They don't have access to the help they need, whether it's legal help or advocacy. Often people who live in smaller communities or closed settings are less likely to complain because they're worried about being labelled a troublemaker in that community, and that community matters to them. And finally, a really common reason is they're afraid of retribution or victimisation. In Queensland, you can get legal help with discrimination complaints from the Legal Aid Commission, from community legal centres, particularly the Aged and Disability Law Centre, and Queensland Advocacy for Inclusion, and also Justice Connect, which can connect people to legal assistance. Finally, I just want to remind you about these words from the late Stella Young, who was a woman with disability who died, sadly, about 10 years ago now. And she said, that quote, "The only disability in life is a bad attitude," and some of you may have heard that said. The reason that's bullshit is no amount of smiling at a flight of stairs has ever made it turn into a ramp. No amount of standing in the middle of a bookshelf and radiating a positive attitude is going to turn all those books into Braille. Thank you. So I'm going to stop sharing and let's have a really good conversation about your questions and anything that came up that I didn't cover off.
Thank you very much, Robin. Before we do, I just want to thank you officially for coming and presenting for us today. And now we will turn the recording off and we will have questions.